that contract stuff. Hang on.
Hi, Manjo.
Yes,
Can I ask a question while
Go
we
ahead.
are waiting?
Yes.
Yes. You see, one of the problems I have with the administrative law is that everything seems to be very overlapping. So let's say, for example, I was just reading on the Wednesbury unreasonableness, and one of them says that it includes, one of the quotes says something about like you considering irrelevant factors, or and that's or not considering what you're supposed to consider is also part of it. Bad faith, dishonesty, giving attention to extraneous circumstances, so on. Then how does that overlaps with another ground? So when you want to apply for your client, do you actually apply on multiple grounds? Do you apply on multiple grounds? Like, because you see, there's a quotation here in Wednesbury itself. The case says bad faith, dishonesty, and attention to extraneous circumstances, disregard of public policy. They are all grounds for unreasonableness, but yet at the same time, they are grounds under their own category. So do you sort of say you want to apply for a review on multiple grounds? Can you give multiple grounds?
Okay. So before I answer that question, let's begin by explaining why we need to be able to cite certain grounds. And as far as judicial review is concerned, and the reason is, for there to be judicial review, you must be able to show that to a court that there is an adversive decision that is contrary to law or that is unlawful. Now, for you, therefore, to make an assertion that an adversive decision is unlawful or contrary to law, you must then be able to show or state why the adversive decision might be unlawful or contrary to law. And so, therefore, that's when you consider different grounds why you're saying that the decision is unlawful. And some of them would be about the breach of rules of natural justice, which not only is about procedural fairness or the right to be heard, but also involves a requirement that the decision maker must be free of bias and must not get involved in bad faith. You also would be able to show whether or not there is an error of law, or whether, for example, there is a jurisdictional error, or you might be able to say that the decision would seem to suggest that there has been rent-free unreasonableness. Now, having said that, the advantage of being able to ground an application for judicial review on the basis of the Administrative Decisions Judicial Review Act would be of 1977 Commonwealth would be that there are several grounds that specific legislation provides as being grounds for judicial review. So that's the advantage there. And so therefore, in relation to in answer to your question, if you're applying for judicial review, if it's going to be based on the ADGR Act, you then must be able to clearly show which, for example, which parts in Section 6 would be the ground for judicial review. If you don't base your application for judicial review under the ADGR Act because the admissive decision does not involve a decision that is based on an enactment, because, for example, the administrative decision might have been based on a general law, such as the law of contracts, or because what you're dealing with is an administrative decision that is based on a prerogative power of the executive, such as the power to enter into contracts, or the general power of the executive to enter into treaties, and so on, or the power of the executive to control or regulate its borders. So in that case, you're not dealing with the exercise of an executive power on the basis of an enactment. So therefore, the ADGR Act will not apply. So again, in that case, you have to be able to explain why, what the ground is for judicial review. Did that answer your question? B?
I hope so. I will try to muddle through.
Okay, so when you are confronted, therefore, with a case problem, the first thing you need to determine, assuming that you're focusing on the question of whether or not judicial review is available, assuming, if that is your question, the first thing you would really like to know is whether or not the ADJR Act applies. Because if it does, you will always be better off applying for judicial review on the basis of the ADJR Act. Because the ADJR Act is actually a piece of legislation that was meant to streamline and provide for more opportunities for judicial redress to individuals, as opposed to having to file an application for judicial review, for example, on the basis of common law judicial review. Because if you were to do that, there are limits in terms, for example, as to the remedies that are available. So in that case, as far as common law judicial review is concerned, you will have to show that you have common law judicial remedies, or it could be equitable judicial review remedies. Whereas if you base it on the ADJR Act, a lot of those remedies under common law are already in the ADJR Act. So it is simpler as a solicitor or as a student in answering an admin law problem to focus first on whether or not the ADJR Act applies. Now, if it does not, then you wish to determine, or even if it does, you would then wish to determine whether or not there might be judicial review on the basis of common law judicial review. And I'm saying that because, as we know, both the federal court and the high court have pointed out that the fact alone that the ADJR Act applies does not mean, therefore, that the common law judicial review is no longer available. It still is. Or the fact alone that the ADJR Act doesn't applies doesn't mean that the high court, for example, will lose its constitutional original jurisdiction under Section 75(5) of the Israeli Constitution. So there has to be a broad application so that even if the ADJR Act applies, the applicant may still ground an application for judicial review also on the basis of a common law judicial review, or even the statutory basis, which is Section 39B of the Judiciary Act of 1903. Commonwealth.
So, Manjo, sorry to interrupt, but
yes,
as far as an order of preference,
yes,
obviously you would first see if you could ground your review under the ADJR Act. Would you secondly then see if it could be grounded under the Judiciary Act, and then thirdly the common law, or is there a different order?
Yes. Firstly, the first thing you need to ask is whether or not merits review is available before you talk about the ADJR Act. Remember, you're better off applying for a merits review because of a number of reasons. One, if merits review is available, you then have an opportunity to attack the correctness of the decision, or whether or not there has been there was in the exercise of the discretion, whether or not there was you can determine whether or not there is a preferable way of exercising the discretion that is given to an original decision maker. So in other words, the advantage of a merits review is that it examines obviously the merits of the decision, both as to the correctness or the preferability of the exercise of the discretion by the original decision maker. That is always your first port of call. Is merits review available? But as we know, a merits review is available only if a statute specifically provides for recourse to the AAT. So in other words, if the statute does not provide for recourse to the AAT, then you can't have an opportunity for merits review. The advantage, as we said, also of applying for merits review is that there is greater scope as far as the powers of the AAT is concerned, because it can substitute its decision for that of the original decision maker, among others. And of course, the fact that rules of evidence are applied liberally and it's also inexpensive and so on. So those are some of the collateral or reasons why you would prefer a merits review. Now, if merits review is unavailable because a statute does not specifically provide for the application for recourse to the AAT to be available, then because you want to attack or challenge an admissive decision, you would then want to know, would judicial review be available? So first, find out if merits review is available because you want to be able to attack the merits of the decision. not just the legality of the decision. Because remember, if you're attacking the legality of the decision, that is of very limited scope. You cannot examine whether or not the decision was decided correctly on the basis of the facts. Judicial review cannot do that because that would go to the merits of the decision. So now, obviously, you would want to be able to apply for merits review if it were available. So that's always the first question: is merits review available? If it is not, and yet you still want to challenge the administrative decision, then you want to know, should I go for judicial review? And that's when you begin by asking, would the ADJR Act of 1977 Commonwealth apply? And that's, again, your first port of call as far as judicial review is concerned, because that is, in fact, the reason why the ADJR Act was applied in the first place, so that things become streamlined and you have clear grounds for judicial review, and as well as the remedies that are available under that specific act. If the ADJR Act does not apply because what is involved is an administrative decision that is not based on enactment, then you want to consider whether or not the Judiciary Act of 1903 applies as far as Section 39B is concerned. But again, your problem there is you're limited to the rates of mandamus, prohibition, and injunction. And as I've discussed previously, especially in the lecture notes and in the lecture video, as far as these remedies are concerned, prohibition and mandamus, for example, are common law, considered to be common law judicial review remedies, and therefore applying common law principles as far as those remedies are concerned. There's certain strict requirements that have to be shown, such as that you're dealing with the exercise of a public power or dealing with the exercise of public authority. So therefore, if you're dealing with an administrative decision made by a corporation, for example, to whom the government has delegated certain powers, writs of prohibition and mandamus will not apply. Or if you're not dealing with an actual right, mandamus and prohibition will not apply. So there are limitations on those judicial review remedies. And so, as far as injunction is concerned, you've got the applicable remedy of injunction. But again, although it's more flexible, there are certain, you still have to be able to show that it is an appropriate remedy, and that there is no other, that common law judicial review remedies are not available, or that there has been the exhaustion of proper internal appeals. So you examine that. So you want to see the ADJR Act, you see the application of the Judiciary Act of 1903, specifically Section 39B. Now, as we know, Section 39B of the Judiciary Act of 1903 Commonwealth is very similar to Section 75(5) of the Australian Commonwealth Constitution, and that is in relation to the original jurisdiction of the High Court. Now, typically in a problem scenario, I would argue against trying to cite that specific provision, because you don't want to engage the original jurisdiction of the High Court if you're dealing with just your own individual application, because the matter won't be important enough for the High Court. So while it is there, the constitutional writ under Section 75(5) is there, it is probably of a matter that is not of sufficient importance as to require the attention of the High Court. So in other words, what you want to do is to limit yourself to recourse either to the Federal Circuit Court of Australia under the ADJR Act, or the Federal Court of Australia under the Section 39B of the Judiciary Act of 1903. So once you've tried to look at statutory judicial review, either on the basis of the ADJR Act or on the basis of Section 39B of the Judiciary Act, and these are not available, then you want to determine whether or not there might be recourse to common law judicial review. So begin with the question of, is merits review available? And then if it's not, is judicial review available?
So once a ADJR Act is available, then do we still want to talk about the alternatives, or we don't have to mention the alternatives?
The way you would answer this is that you would probably say that there is a possibility of applying for judicial review on the basis of the Judiciary Act of 1903. You can say that. But given the fact that the ADGR Act of 1977 applies, then you will refrain from making a further discussion as to other legal basis for judicial review. So it is sufficient that you flag in your answer the availability of judicial review on the basis of common law judicial review, for example, or Section 39B of the Judiciary Act. But you would like to focus your answer on the ADGR Act because the Act applies. And where it applies, that is the initial basis for your application for judicial review. And you'll probably say as well in your answer that you are noting that the Federal Court of Australia and the High Court has pointed out that even if the ADGR Act were to apply, it does not mean that other statutory provisions no longer apply, nor would it mean that common law judicial review is no longer available. But because the ADGR Act applies, then you are focusing your answer on that specific statute.
Manjo,
yes.
Can I please ask, you were talking about the remedies available under the Judiciary Act.
Yes.
And in my extraneous reading outside of the course notes,
Yes.
I found that you didn't just have those limitations as far as the remedies that you discussed, and that certiorari and declaration and habeas corpus were also available.
Yes, that's right.
Okay.
Common
Yes,
law,
that's
under
correct.
common law,
Okay.
under common law.
So that applies to the Judiciary Act?
No, the Judiciary Act is limited solely, as well as Section 75(5) of the Australian Constitution, they're limited solely to remedies of prohibition, mandamus, and injunction. So in other words, if assuming that you're challenging an administrative decision, but you cannot, and then the writs of prohibition and mandamus are not available, so in that case, you can't have recourse under Section 39B, for example, and neither can you have recourse, for example, assuming it doesn't apply. You don't have recourse under the ADGR Act, then you will want to consider the possibility of applying for judicial review on the basis of common law judicial review, where, as you pointed out, you do have the remedies of certiorari, and you have the remedies of declaration as well. And so if you recall, in the case of Green versus Daniels, notwithstanding the fact that the court was unprepared to order the decision maker to provide the benefits, it did issue a writ of declaration.
Okay, so my reading was that the remedies of certiorari and declaration and habeas corpus were available under the Judiciary Act when you were applying under Section 39B1, as long as they were associated with one of the nominated remedies, being mandamus, prohibition. No, that's incorrect?
No. Because Section 39B is specific. And the only writs available under Section 39B would be prohibition, mandamus, and injunction. So in other words, if you're seeking a declaration or seeking certiorari, that is a common law judicial review remedy. Which actually means that the power of the court to undertake judicial review and grant these other remedies such as certiorari and declaration and even habeas corpus would exist even if there had been no law such as the ADGR Act or the Judiciary Act of 1903. Because remember, the ADGR Act and the Judiciary Act of 1903 are creations of the Commonwealth Parliament. Which means because they were created by the Commonwealth Parliament can vary them or repeal those legislations. So the point about the common law judicial review is that even if these had not existed, the courts, the superior courts at least, have an inherent jurisdiction or the inherent power to issue the writs of mandamus, prohibition, injunction, as well as declaration, habeas corpus, and certiorari.
Thank you for that, Manjo. I have actually one other question which is outside of this week's topic,
Yes.
but it touches on a question that was asked in last week's tutorial. And my question is regarding a situation where you have the option of both applying under judicial review and merits review.
Yes.
And if an individual were to choose to not undertake their option of merits review and simply apply for judicial review, there's a section in the ADJR Act that stipulates a discretion of the court to decline approval of that application. But so it's actually section 10 to number 2, that adequate provision is made by any law other than this Act under which the applicant is entitled to seek a review by the court, comma, by another court, comma, or by another tribunal, comma, authority or person. So if both options were available, so there was an error of law, but there was also a merit issue, and merit review was available, and the party decided that they were not going to seek merit review, they just simply applied for judicial review, under that section, is it likely that the court would decline to accept the application?
Okay, before I answer that question, I'm conscious of the time. It's kind of 7:40 now. What is the pleasure of the class? Should I answer that question, or should I focus now on the topic on access to information? Because we're kind of going off topic. So is that a yes, like I'll answer the question, or should I go to the tutorial question now? So well, essentially, so there is no complaint. Is it in the exam? Yes, it is. That is a very important question that was actually raised. It's very relevant. So, okay, good. Okay, so the general question seems to be that, you know, even if we're kind of off topic, but it is a legitimate question. Now, so before I answer that, let's kind of begin a backgrounder here. It's not so much, you don't address that question by simply determining whether or not is merits review or judicial review preferable. That's not actually the correct question. The correct question is what is actually appropriate. So in other words, if you're dealing with a legal question, you don't apply for merits review. So in other words, if the adversive decision is made on the basis of the fact that there seems to be a legal error as far as the adversive decision is concerned, then in that case, although merits review can do something about it, the decision of the Adversive Appeals Tribunal on a question of law is never final or determinative. So therefore, if you're actually dealing with a legal question and you know that the ADJR Act applies, you would be better off applying for judicial review. Okay? So in other words, in that case, having said that it's always a question of what exactly is the question that is involved. So in other words, there is an adversive decision. The question asked is, this adversive decision, does it actually involve, do you attempt to challenge the decision on the basis of the merits, or do you wish to challenge the decision on the basis of the fact that there is a question of law involved, that the decision is actually unlawful? Because if the decision is actually unlawful, you should seek recourse under the ADJR Act, because even if you were to go to the Adversive Appeals Tribunal, which we know that when the Adversive Appeals Tribunal makes a determination as to its applications, it actually looks at the merits of the decision and also touches upon the legality of a decision, as we know from the case of Brian Lawler Automotive versus the New South Wales Collector of Customs. But that is only provisional. So if what you're trying to really look at is the legality of the decision, focus on the judicial review. Now, so it all depends on the nature of the attack or the challenge you're making against an administrative decision. Now, from Vivian, there's a question, wouldn't judicial review be more expensive than merits review on a question of law? Again, it's crucial to point out that questions of law are never within the jurisdiction of the AAT. Let me repeat. The Administrative Appeals Tribunal has no jurisdiction to resolve or determine questions of law. The jurisdiction of the AAT is limited to the merits of an administrative decision. So that has to be very clear from the very start. Before we talk about, inexpensiveness, rules of evidence being liberal as far as merits review is concerned, as a basic point of law, you need to be able to articulate in your answer the key distinction between merits review and judicial review. Because if you confuse the two, you'll end up with the wrong answer. So merits review focuses on the merits of the decision, whether or not the decision was the correct or preferable one, as we know. And even if the AAT may actually be able to kind of examine the legality of a decision, but that is only provisional, according to the case of Brian Lawler Automotives versus Collector of Customs New South Wales. So if it involves a question of law, only Chapter 3 courts have jurisdiction to resolve errors of law or questions of law, never the AAT. Okay. So yes.
Manjo, my question was, if you had a fact situation in which you could meet the criteria to apply for judicial review, particularly under the ADJR Act, and you could also meet the criteria to apply for merit review, if the person chose not to avail of their opportunity to apply for merit review, is it likely that the courts would decline their application for judicial review based on the section of the legislation
Yes.
I read before?
Yes. The court is likely to decline an application for judicial review if actually merits review is available.
Thank you. That's fantastic.
Okay. So as pointed out by Peter Furyk here, if it's a question of law in the merits context, simply means that question of law doesn't automatically lock out a merit review. So in other words, as pointed out by the case of Brian Lawler Automotive versus the Collector of Customs of New South Wales, just because there is a question of law that is part of an application for merits review will not deprive the Administrative Tribunal or the AAT from exercising its jurisdiction to review the decision on the merits. That's the whole point there. Okay, so we could probably proceed. So that was a fantastic question. Very good. So that, kind of helps the students have a better sense of how actually to attack a problem question, whether or not you're applying for merits review or judicial review. So in other words, an answer where you simply say go for merits review because it's cheaper and you don't need a lawyer, that is a low-level answer because it doesn't really address the question of why merits review or judicial review is appropriate in the first place. Okay, so let's proceed now to I'm not going to look at the chat box now because I want to move on for now. And I'll try to get back to that in a short while. So let's go to access to information. So this week, we're dealing with access to information, particularly the Freedom of Information Act. And I came across an interesting article. So I'm going to have to get out of my screen share. So I could show you. Oh, wait. How come I'm not appearing? Can you see are you able to see what I'm showing now or not? Oh, you are. Okay, so
yes.
Very good, because it's not appearing on my screen. This is a news story which appeared in the Sunday Mail yesterday. And the topic is Rudd down. XPM denies taxpayers were touched up for back pain relief. So in other words, the whole point was that during the time that Kevin Rudd was the Prime Minister of Australia, it seems that he had actually had a rub down or massages. And it would appear, the question is, would there actually be a right on the part of an individual to get access to the documents that would show that Kevin Rudd was actually using taxpayers' money for back pain relief? That seems to be a relevant question. And Kevin Rudd seems to be making the assertion that it's going to put him to an embarrassment. It will humiliate him if the information concerning, his use of taxpayers' money would be provided access to the public. Okay, I'm not going to answer that because I think it's an interesting final assessment question, right? Does he actually have a right to say that the freedom of information doesn't apply because it's embarrassing? So I'm not going to answer that, except to say that it's something you should think about, because to me, it's an interesting question that should be asked in a final assessment. So I'll leave it at that.
Is that a hint?
It is a hint, yes, because I found it interesting. Okay. So let's
Manjo,
talk.
can you
Yes.
just, for all of those us that don't reside in Queensland, can you just give us a reference to that paper so we can have a bit of a read of it?
Right.
Please?
It's in the Sunday Mail. It's actually on page 4. So, oh yeah, because not everyone lives in Queensland. So it was published in the. I'll probably post this. Yeah, as a think piece for it's something for you to think about. I'll scan it. I'll post it either tonight or tomorrow, or maybe on Wednesday, because I'll be away. I'll be away for a school retreat. But I will certainly post this within the week. The title is Rub Down, meaning rub down. XPM denies taxpayers were touched up for back pain relief. And I think it's a relevant question as far as freedom of information is concerned. It's interesting because if you were to go through the textbook, former UK Prime Minister Tony Blair had actually pointed out that it was one of the most incorrect decisions that they had made when they passed the Freedom of Information Act in the UK. Because by passing the Freedom of Information Act, it limited the power of the politicians or the government ministers to kind of, at least in the UK context, to discuss sensitive information freely, because they know that because of the Freedom of Information Act, they're always in the glare of public opinion, and that the public is not then in a position to always access certain information which they would have thought were made in confidence. And in particular, the whole point there in relation to the US, so there you go, from Vanessa Page. It also appeared, it would seem, in the Daily Telegraph. Well, good, very good. Now, because the other interesting point, as I pointed out in my weekly message today, is that, for example, you have the what has happened in the US about are you familiar with the Abu Ghraib abuse of alleged terrorists, where there were a lot of very disturbing images or disturbing photos of the way that terrorism suspects were treated. And there is an ongoing court litigation where certain public, certain advocacy groups are seeking for access to these images. And of course, the White House in the United States, meaning President Obama, is trying to prevent the publication of those images, mainly because not only do they perhaps concern matters involving national security, but can you imagine the kind of inflammatory effect it will have for people in the Middle East and for people, for example, in Afghanistan, Pakistan, and those places where they would then be very angry at at American citizens. So again, that brings to the question of freedom of information. So actually, the notion of freedom of information is a very important topic. So going back, so as far as tonight's topic is concerned on access to information, after studying this topic, you should be able to discuss and explain the importance of freedom of information legislation, key principles of the FOI Act, the legal right of access under the FOI Act, and exemptions, conditional exemptions, and public interest factors under the FOI Act. Okay. So let's try to discuss this first question. And yeah, well, if necessary, I'll come up with a problem scenario in a short while. what role does the Freedom of Information Act 1982 Commonwealth play in administrative law? And let's begin by trying to remember what exactly is administrative law all about. Because so far, we have been talking about administrative law in the context of merits review and judicial review. We haven't even been talking about the Ombudsman. So does the Freedom of Information Act have any role to play in administrative law? So what exactly is administrative law, and what exactly does the Freedom of Information Act 1982, if at all, have in relation to administrative law? And so if you could, please provide your answers in the chat box. Ooh. So I've got some here which are quite lengthy. I'm not sure if I'll be able to post all of them on the screen. Okay, I've seen some answers here, but honestly, I'm not sure they answer my question. So that's what you need to be careful about. It may be apparent to you that you seem to be answering the question, but so far, I'm not convinced that most of the answers here actually answer the question. So we've got answers like maintain transparency and accountability, but what has that got to do with administrative law?
Manjo, doesn't it mean that you have an opportunity to see what information the government has or has used in making a decision, and perhaps that information may have been incorrect? So it gives you an opportunity to have that information corrected?
Okay. Yes. So
my answer is that it enables the general public, who are the electors of the government and who are funding the government, to have access to the information necessary to keep the government accountable.
Okay. So why is that? What has that got to do with administrative law?
Well, administrative law is all about individuals being able to seek recourse when the government acts outside of their power or acts illegally.
Very good.
Yeah.
So that is the way you should approach a question such as this. Begin by, stating what exactly is administrative law. So as you pointed out, it's all about, seeking redress for the actions of the executive when they may be detrimental to the interests of the public. And so therefore, in that case, if your purpose is to ensure that the actions of the executive government, so not just the government, it is the executive government in particular. Okay, so remember that the government, there are three branches of government. You've got the parliament, you have the courts, and you obviously have the executive. Administrative law has nothing to do with the exercise of powers by the parliament and by the courts. Administrative law is limited to the exercise of powers by the executive. So we have to clarify when you come up with an answer. It has to be specific that you're dealing with questions in relation to decisions or actions by the executive government as they affect individuals or the public. Okay, so an answer here from Sarah. Administrative law is a body of law that regulates government decision-making, allowing legal recourse to challenge or seek review of government decisions and actions. Therefore, the fundamental principles to accomplish this aim include the safeguarding of individual rights by ensuring transparency and accountability of both the process and the result. And this is achieved, for example, by the Freedom of Information Act. So that is the way you would try to answer a question such as this. Okay, good. So what role then does the Freedom of Information Act play in administrative law? There you go, from Sarah. So we've got a very good answer here from Sarah. I'm going to put it at the top. So the Freedom of Information Act safeguards these principles by ensuring a legal right of access is maintained with appropriate avenues for recourse. Transparency and accountability underpin the effective and fair. Too broad. Getting there, so the approach was correct, but too broad. I didn't see the connection to the Freedom of Information Act. Was a good approach. Okay. So an answer from Peter. The Freedom of Information Act allows for openness, transparency, and rationality. Okay. Broad, quite broad. And so an answer like this, which is good, connected to our idea of what administrative law is all about. So there are two aspects to the question. One is what the Freedom of Information Act is about, and how the Freedom of Information Act relates to administrative law. In other words, what is the role of the FOI Act in relation to administrative law? So you have two questions, actually. There is a single question, but there are two aspects to the question that need to be answered. So you answer in the context of what the FOI is, FOI Act is, and how the FOI Act relates to administrative law in terms of its role in administrative law. So that is the way you should be approaching the question.
Well, I think that before you can embark on any kind of challenge to the decision, you actually first, in reality, have to apply the Freedom of Information Act in order to obtain the patient's charts, records, or whatever decision, explanation of any decision that was made before you can examine these all these paperwork and then decide what are the grounds you want to apply for. So it's preliminary to any kind of challenge to an administrative decision.
Wait, when you say challenge, are you referring to merits review and judicial review, or judicial review?
I think in both cases, you will still need to go and obtain the records before you can see how and why the decision was made before you can go about challenging it.
Okay, very good. What do others think about the statement of B?
Well, I think that if you were doing a judicial review, normally provided with or able to acquire a statement of reasons for the decision. And as judicial review is generally a question of law, then obtaining background information on the on facts and findings probably isn't as important as it would be in, say, a merits review. Okay.
So you're heading in the right direction, Kim. Now, but the question for me is, where does the Freedom of Information Act fit in this discussion? Because on the one hand, B was drawing a connection between the Freedom of Information Act and merits and judicial review. And then Kim had pointed out that, when a decision, for example, is made by an administrative body, typically there would usually be, reasons for the decision. And so the question I have in mind is, so what has the FOI got to do with it?
Well, FOI enables individuals to understand why and how decisions affecting them are made.
Okay. So maybe yeah.
When they know that, then they can question or support the decision.
So maybe my question is this. In a usual case, if a person were aggrieved by an administrative decision, before that person will apply either for merits review or judicial review, would it be usual for that person to actually seek information under the Freedom of Information Act of 1982? Would that be the usual case?
Well, you would think so, because that information, how they came to that decision.
Okay, can I get the comments of everyone? Because now what's happening based on the discussion so far is that there seems to be a view that the Freedom of Information Act is closely connected to an application for merits review or judicial review. Would the others agree? I mean, if you follow the statement of B, it is as if trying to access information on the basis of the Freedom of Information Act of 1982 is a preliminary act to an application for judicial review or merits review. Would you agree? Okay, from Michael's, can be some. From Libby, you cannot prove illegality without evidence. Gonna go back to that. I want that. I'm gonna put that in the chat on the screen. From Vivian, not necessary. From Peter, if you have been, or if you're unhappy with the decision, you would use the FOI to see what grounds you have to argue otherwise, and what avenues of redress you have. Interesting. Is that the way it works? So in other words, to you, does it seem to be the case that the Freedom of Information Act was kind of enacted in order to allow individuals access to the reasoning of an administrative decision maker? When people apply, okay, let's put it this way. Yes, go ahead.
Sorry, I was going to say, I don't believe that that's why the FOI Act was initiated. I just think it's an avenue that you can use. And if you were, if you had made an application for a review of a decision and it was refused, you would want to know what process and what information the body took into consideration to come to that decision.
Okay, so I would be inclined to agree with what Maggie was actually saying. The Freedom of Information Act is related, obviously, to applications for judicial and merits review, but it is quite distinct. In fact, if you examine the applications made by individuals for access to information under the Freedom of Information Act of 1982, it seldom has anything to do with applications for judicial review or applications for merits review. They simply want access to information. And in fact, the initial concern of those who were against the idea of the Freedom of Information Act was that it was going to be journalists who were gonna mine and exploit the Freedom of Information Act to gain access to sensitive government information. So the Freedom of Information Act was not mainly driven by the desire to enable potential applicants for merits review or judicial review to get access to the reasoning behind the decision. Because remember, for example, under the ADJR Act, once it is clear that a person can apply for a judicial review, then as a matter of law, the decision maker will be required to provide reasons for the decision. So in that case, the Freedom of Information Act would have been superfluous. Correct? So in other words, we should therefore see the Freedom of Information Act as providing a different way of promoting ways by which there is government accountability, and to ensure that there is no excessive or unlawful exercise of executive powers. So it is quite distinct from, the Freedom of Information Act, therefore, is quite distinct from the idea of merits review and judicial review. It can happen, but actually it seldom happens. In fact, if you examine applications made under the Freedom of Information Act, in many cases, it's either because journalists want access to deliberations made by government agencies. If not that, it is because the individuals would wish for their records to be corrected. So remember, the government has individual records. It could be about records under certain link, or for those who have become immigrants, it's because the Department of Immigration would have information concerning individuals. So individuals would then apply under the Freedom of Information Act of 1982 to determine what records the government has in relation to them. And that has nothing to do with a possible action for merits review or judicial review. It's quite different. So while there is often an intersection between the Freedom of Information Act of 1982 and applications for judicial review and merits review, that seldom happens. So from Forbes, under the FOI, applied to immigration for personal data concerning travel records. That's right. And that has nothing to do with an intention on the part of the individual to apply for merits review or judicial review. And I think, as pointed out by Kim, there are strict limits. There's strict time limits. So therefore, if you're trying to gain access to freedom of information, that will not stop the prescriptive period during which you need to apply an application for judicial review or merits review. And that can take time. Remember, there are other periods during which the statutory agencies are required to provide access to information. And while you're trying to seek recourse in that, that will not stop the prescriptive periods from running for the application for judicial review and merits review. From Brad, FOI to find out if a safety certificate was provided on a property and any complaints to the Electoral Safety Commission. So we've got fantastic examples here of how the Freedom of Information Act was actually used by individuals, which had nothing to do with possible applications for judicial review. So there is a connection, but it's actually a loose connection. So the FOI is a separate category altogether. Now, from Erin, Brad, wouldn't you be better off going through the Ombudsman for electricity and water? You could. But, well, if I were to answer that, the role of the Ombudsman is quite different from the freedom of information. It's possible you can go to the Ombudsman, but if you don't have the information, what then? So you'd probably require certain information before you go to the Ombudsman. So from B, but I thought the question was how FOI connects. Exactly. The question was how FOI connects with administrative law. And that is the whole point. Administrative law is not limited to whether or not you can have an application for judicial review or merits review. Administrative law is broader because administrative law is an area of law that seeks to regulate and control executive government action. And the way to regulate and control executive government action is not just by looking at recourse under merits review or judicial review, but also through the Freedom of Information Act. Because if the public have access to critical government information, that obviously is a way by which excesses of government action would be controlled. So for example, it would not be possible, therefore, for former Prime Minister Kevin Rudd to say that the public shouldn't have access to his records of whether or not he used taxpayers' money to get a background. The Freedom of Information Act, regardless of whether or not there is a possibility of applying for merits review, judicial review, that would be an extraneous matter from the question on the part of the public of whether or not Kevin Rudd actually used taxpayers' money. So administrative law is broader than the ideas of judicial review and merits review, because administrative law is all about finding ways by which executive action is controlled or regulated as far as they impact on the rights and freedoms of individuals. Okay. Can we move on to the next question? So what I emphasized there was that we need to see that administrative law is not all about merits review and judicial review. You can have administrative law in the context of an internal review. You can have a way of promoting administrative law by using the Freedom of Information Act or going to the Ombudsman. Okay, now the other question we ask is, what are some of the conflicting themes in having a freedom of information legislation? Okay, from B, very good. There's the conflicting theme. You want, on the one hand, you want, okay, how come I'm not able to control my PowerPoint? Hold on. There, okay. So on the one hand, you have themes concerning transparency and privacy. So this is from Brad Marler. On the one hand, freedom of information legislation is designed to facilitate openness. On the other hand, we need to protect privacy and confidentiality. Very good. Okay, from Tawanda, there's the matter of national security as well. So on the one hand, you want freedom of access to information, and yet you also have concerns about national security. So from Jacob as well, there's a question of keeping secrets and issues of disclosure. Very good. And from Brad Corby, there is the potential for abuse of information for personal benefit, and that it is not necessarily for the public benefit. Questions from Peter, efficiency and openness. From Catherine Wood, Prussian government regarding secrecy and government secrets used as weapon, usually against the government power. Okay, would anyone wish to use the mic? We've got a lot of good answers here. Would anyone wish to discuss his or her answer by picking up the mic? So the final one is coming from Vanessa. Would anyone wish to use the mic?
Manjo, just before someone answers, I just wanted to tell a very quick story. I remember when the Queensland government changed its Freedom of Information legislation to the Right to Information Act. This is a few years ago now. I remember there were stories that were told. One of the provisions that was changed was the exemption provided to cabinet documents. Apparently, under the old Freedom of Information Act, it was common practice that at cabinet hearings, at meetings of cabinet, public servants would make large trolleys full of boxes of documents, simply wheel them into the room, leave them there, and at the end of cabinet, they'd wheel them out. They were never referred to, never discussed. But because they had been within cabinet, they were covered by the exemption. So any public servants that wanted to hide any documents from the Act, all they had to do was wheel them into the cabinet room, and that was it. And that was one of the things that changed when they updated the legislation.
Fantastic, Tim. That's a very good piece of historical information. Thank you. Now, in the context, yes.
Manjo, I get what I was saying there in regards to the abuse of the information.
Yes.
I think Brad Muller put up something on one of his answers. What was it? $36 million to administer it, and they've only recovered 1.7% of.
That's right.
By charges. So
yeah.
You have people that seek. If you look at things like in the US, after 50 years, they released information from the FBI in regards to the assassination of Kennedy. I mean, so what? So the government have incurred all these costs for someone to have a personal gain to get a Facebook profile. I think people can really abuse that process of getting information that really doesn't assist in the better administration of government.
Interesting point. Brad Marler has provided the statistics there, the figures. So in the Australian Information Commissioner's FOI annual report of 2010 to 2011, the estimated cost of administering the FOI was at $36.318 million. And of this, only 1.7% was accrued in FOI charges. So can anyone comment on what Brad Corby and Brad Marler has posted on the screen?
So I'll call him back. Yes.
Yes. Did anyone want to make a comment?
Point I want to make is that people also try not to put any information down, knowing that it can be subject to FOI. And a very relevant thing is because I work in a hospital.
Yes.
And it used to be that mortality and morbidity rounds, we used to be able to speak freely, but now, of course, nobody dares to say anything, and all you have is a discussion has taken place. That's it. And any recommendations, and there will be no further detail. The secretaries will be told to destroy the slides, delete the slides of the relevant presentation before storing them. So in this way, there would be actually no way to discover what actually happened. And because of this act, you know, it's actually encouraging secrecy and not transparency.
Very interesting point. It would appear to me that a lot of people have a very pessimistic view to the legislation. Can somebody, you know, provide a comment to that?
You there, Manjo? I can.
Yeah.
I can second that. I know for a fact that.
Who would this be? Sorry, I couldn't say that.
Michael.
Michael, yes.
Yeah. There are systems now in government. They're like 2 email systems, and that now one isn't recorded. And there's other things that, you know, that are getting used more and more, the SMS and all that between government people.
Yeah.
So I think you have your normal Outlook, but you also have a system called Link now that self-deletes pretty quickly.
Yeah.
Which is, you know, in some ways fair enough for some privacy. But how do you trust that the official government line, official stuff is not being lost in the mix?
I recall, for example, in the United States, that during the time of Hillary, I would assume you would know Hillary Clinton. Not only is she the wife of the former U.S. President Bill Clinton, but she was formerly the U.S. Secretary of State. And there had been a complaint because although she had an official email, she actually used her personal email in a number of her communications with key staff. And it would appear that she did that because she was concerned that a lot of the communication, if it was going to be based on, you know, the government email, then it was likely not to be covered by the protection. The exception under the Freedom of Information Act in the US. So as pointed out by Michael, it seems to be the case that there are many instances where government officials would then have a parallel system of emails, one that is official, the other one that is public. The other one that is private. And it makes you wonder whether or not it is the Freedom of Information Act is actually achieving its purpose of having greater transparency in the government and disclosure if government officials then seek to circumvent the law by, you know, ensuring that, well, in the case as pointed out by B, for example, some documents are then deleted, or some documents are probably stored in a private channel. So what do you think?
Manjo, I was listening to the ABC the other day, so I'm showing my age, but they sought information from via the FOI in regards to Paul Pasali and an email that he'd sent to the CEO, which at the end of the day, basically, he followed the procedure. His wife worked for him for a period of time until they could find someone that would be able to drive for him because he has, I think, MS or muscular dystrophy, one of those.
Yes.
And, you know, so it just seemed to be, you know, a witch hunt with an election impending in 6 weeks' time. And I thought that was very, you know, significant abuse of that freedom of information for the personal gain of a journalist, as I refer to as glorified advertising salesman.
Yeah, but again, we were probably making the assumption that journalists don't have a role to play in administrative law. So what if Yes.
Look, I think they should use it for something relevant. That seemed rather irrelevant, with a very much a slant towards throwing a nigger in the woodpile, as I say, or red herring with an election pending. It just seemed irrelevant and very much an abuse of the FOI.
That's right. Okay. So there are no clear answers to this question. The fact remains that the genie is now out of the magic lamp. There's no way of putting it back. So the freedom of information is there. The legislation is there. And obviously there are advantages and disadvantages. But it's crucial that we're able to clearly identify the conflicting themes in the freedom of information legislation, and for us to remember that the freedom of information legislation is there not simply because it assists individual potential applicants, but because in general, if freedom is more widely accessible to the public, then the likelihood that the executive government will act in a way that is detrimental to the interests of the public in general will be less likely. So in other words, because of the freedom of information, the chances of an individual applicant having to therefore complain about the wrongness of an administrative decision will probably be ameliorated or reduced, because the existence of the freedom of information legislation will likely mean that executive government officials are less likely to act in a way that is detrimental to the interests of the public, given the fact that they know that what they do or what they say is likely to be available to the public. And so therefore, they are more likely to act in a more responsible way. At least that's what we hope is likely to happen. Okay, so I guess that's it. Well, I don't want to answer the notion about Kevin Rudd, because I think it's an interesting final assessment question. Keep it in mind. Keep it in mind. I don't want to, well, yeah. Okay. Any questions before we end tonight's session on the Freedom of Information Act?
I just have one, Manjo, just about that article. You will post it, because the link that was posted earlier in the chat, I can't actually get through. So would you post that article?
I will post it. Yeah, I will post it in Moodle. I will. So keep a close eye on it. What was that, Jacob?
Well, I just said thank you.
Okay. Okay, good. So we're gonna have a final session, a final tutorial on Friday, which I think begins at 8 o'clock. So it's gonna be an interesting revision tutorial, not only because I'll be discussing possible questions, but really I'm interested in trying to give you guidance on how to come up with good, well, I think, in my view, good ways of approaching assessment questions. Because, as you will have noticed in the course of the legal memorandum assessment, it is not enough that you're able to cite the law and try to just connect it to apply the law to the case facts. You need to be able to provide an argument. And all of this, the discussion of the case law, the discussion of the legal principles, and its application to the case facts actually leads to a logical conclusion. And that is done through a process of argumentation. So I'm going to discuss that in the revision tutorial on Friday. Okay, so I guess that's it. Thank you, everyone. Huh?
What time is it Friday?
It's going to be from 8 to 9.
Okay, thank you.
Okay, thank you, everyone. So thanks for joining us tonight again, and I'll see you again on Friday. Good night. Bye.
Thanks, Manjo. Good night, all.
Thank you.